Right from the start, the judge sets a powerful tone. When a judge says someone's actions made their stomach turn, you already know this case involves something serious. But what exactly happened on that Christmas Day incident that shocked the court so much? Stick around, because this courtroom exchange gets intense very quickly.
The actions that you exhibited that day made my stomach turn. All right, let's go on the record in the matter of the state of Michigan versus Braxton Bailey, P6-4. Is Ms. Henderson still present?
Unfortunately, with Mr. Bailey's attorney being late, she had other engagements she had to go to. Unfortunately, she will not be here to see the justice received.
All right, I was unaware that she had to leave.
Yeah, she's been here approximately 3 hours.
All right, yes, I'm very much aware of that, sir. Thank you. All right, counsel, your appearance, please.
James Anderson, appearing on behalf of Braxton Bailey, Your Honor.
Mr. Bailey, your name for the record, please.
Here's an important courtroom rule that many people don't realize. Punctuality is not optional for attorneys. Courts run on extremely tight schedules, and failing to notify the court about delays can actually lead to penalties. In this case, the judge is clearly frustrated, not just about the delay, but about the lack of communication.
Braxton Bailey.
Okay, and so, counsel, I addressed this slightly when you zoomed in, but this matter was scheduled for 9:15. We had a victim that's been here since 9 o'clock on a very violent case. And there was zero communication with this court. At some point, you realized that there was a time conflict, correct?
At some point I did, Your Honor. I had a matter scheduled in the circuit court for 8:30. I decided to go to that matter first, hoping that I would have enough time to not be so late in this court. Unfortunately, it did not work out the way that I planned. I understand, and I apologize for not contacting the court to let the court know that I was being detained in Hell Bay.
Okay. Well, counsel, clearly, if you had an 8:30 circuit court matter and a 9:15 matter here, you were never going to be here at 9:15. There was not even a possibility of that even happening. And you did not even contact into the court. Zero regard for the court time, zero regard for the victim time, and zero regard for your client's time. And even after you were here, after 9:15, you didn't even contact the court until this court contacted your office multiple times. Only then did you contact into the court.
Again, Your Honor, on some of the matters I was on the record, most likely, I did hear my phone buzz while I was on the record in court. As soon as I was able to get out of that, I contacted my office. And then I immediately, as soon as I was able to contact the court, and if I zoomed in to see if I still needed to show up in person. You know, oftentimes in the circuit court, I've appeared on matters at 8:30, and they've been finished in enough time for me to arrive here in court on time. Unfortunately, it did not work out this morning. Again, I apologize for not letting the court know.
All right, well, and the court can understand that, counsel, and the court can understand the demands on an attorney's schedule in multiple courts, but the court cannot understand the lack of communication.
And there it is, a $100 sanction. That's essentially a financial penalty imposed by the court. It's not about the amount of money. It's about accountability. Judges often use sanctions like this to send a message. Respect the court's time, respect the victim's time, and respect the justice process.
So the court's going to order a $100 sanction, counsel.
I don't know. Since the court is well aware that the circuit court takes precedence over matters in the district court, again, I apologize for not contacting the court, but I don't know that a fine in that regard would be appropriate.
Counsel, you didn't communicate with this court at all. This court had to contact your office multiple times, and that was over an hour and 20 minutes after you were scheduled to be here. Your client was sitting here without communication. Your client also has been sitting here now for almost 3 hours. The victim was here without any communication. There is zero communication. If you would have contacted the court counsel via email, even yesterday or Monday, the court could have made some arrangements and notified the victim and your client. We could have adjusted the time that you needed to be here, but that didn't occur. And there should have been communication with the court, and there was none. So the court finds the sanctions appropriate. And now we don't have a victim here to speak on her behalf, as she had prior engagements that she had to attend to, it appears. Sir, your name for the record, please.
Shane Boyd, I'm her stepfather.
All right, can you spell your first and last names, please?
SHANLLOYD.
Okay. And was Ms. Henderson intending on addressing the court today?
Unfortunately, now she's not able to.
That wasn't my question, sir. When she was here, was she intending on addressing the court, or was she here simply for observation?
I believe just for observation.
Okay, thank you. Yes, Court Officer Midlars.
She just spoke to you, she advised me she did not want to address the court.
Counsel, is that your phone on?
There's an alert.
Please make sure it's on silent. I'm sorry, what was that, Court Officer Midlars?
The victim assured me that she did not want to address the court, but she wanted to see justice prevail.
Okay, thank you. Okay, so counsel, I asked those questions to determine whether or not we can proceed, or if we needed to set it for another date, but we will proceed. Since Ms. Henderson was not intending on addressing the court, she was here for observing the sentencing. And so counsel, today is the date scheduled for sentencing on your client's plea to domestic violence aggravated. The felony of assault with intent to do great bodily harm less than murder was dismissed by way of resolution between counsel. And counsel, do you have an opportunity to review the report and recommendation with your client?
Yes, Your Honor, I have reviewed the report and recommendation with my client. The only correction to be made is on the criminal history. It says the defendant has 5 warrants. We don't exactly understand what those warrants are. I do understand he does have some traffic matters. He presented to me this morning receipts from payments from the court on those traffic fines.
Okay.
That's what those were.
All right, sir. Where did you make those payments? And I'm sorry, when did you make those payments?
So the one you gave you the right date. These payments was made on February 26th.
Okay. So let me just go through, because I'm showing it as of March 6th. This is what is showing.
Now the situation takes another turn. The judge starts listing multiple outstanding warrants, mostly related to missed court appearances and unpaid tickets. While these may seem minor individually, in court they create a pattern that can seriously affect how a judge views a defendant's responsibility and credibility.
Warrant out of 18th District Court in Westland on October 2nd of 2024. That is for failing to appear for a show cause hearing via Zoom on a plate violation that apparently wasn't paid. The other warrant is May 7th of 2025 out of the 28th District Court. You failed to appear for an arraignment on a driving license suspended. September 15th of 2025 out of 19th District Court. There was a bench warrant issued for failed to display a license, and you did not appear for the bench warrant hearing. Then January 26th of 26 in the 22nd District Court in Inkster indicates that you failed to appear for a show cause hearing that you had for your speeding ticket that apparently you didn't pay. Also, a red light ticket out of the same court, the same week. We had a show cause hearing and didn't show up. Are those any of the places that you paid tickets at, sir?
No.
Okay, so those are the 5 warrants.
Thank you.
You're welcome.
Yes, I did. I haven't had any mail. I haven't seen any mail. Yes, you
So,
said.
sir, I did take that into consideration with your January 26th one,
Mhm.
right? The date of the warrant for January 26th. So I don't know what date that show cause hearing would have been scheduled. It doesn't indicate that. It just shows the date of the warrant was January 26th. The court did note that when I was reviewing the sentencing, that you have not been back at the home since you were arrested on December 25th of 25. So I don't know when that one was scheduled, right? But now you're on notice that you have the warrant out of Inkster, and because you didn't show up for a show cause on a ticket that appears from 2021 that you owed fines and costs on. The other matter, sir, the court would presume that it was sent to the address you've been residing at. Those are all prior to December 25th. All right. As to sentencing counsel.
Aaron, I asked the board follow the recommendation, since recommendation rather,
Sir, I need to tell you that when I was reviewing this matter,
This is the emotional core of the hearing. The judge describes allegations of choking, punching, and violence during a domestic dispute. On Christmas Day, no less. In cases like this, judges often focus not just on the crime itself, but also on the impact on family and children. That's why the judge begins asking deeply personal questions about the defendant's role as a father.
the actions that you exhibited that day made my stomach turn. You punched Miss Henderson, with whom you have 4 children, correct?
No,
No, 1 child?
3.
You have 3 children.
Yes.
1 child is not yours?
Yes.
Okay, is that the 5-year-old?
No, I believe he's 6.
Oh, okay. So you have 3 children with Miss Henderson, one of which is 8 months old. And I believe she had just gotten back from the hospital with the 8-month-old, correct?
Correct.
Right. And it's Christmas Day.
Correct.
Right. And so the allegations are that you choked her, threw her out of the chair, you punched her in the face so hard that her tooth was knocked out. And then you hit her in the head with a trash can. And in fact, one of the statements that I reviewed was that you were holding her with your hand by her neck. And then you punched her in the face.
That's not what happened.
Sir, the fact that you put your hands on her at all is a problem. The children were present.
That's not true either.
The 8-month-old wasn't present?
No,
None of the children were present.
no,
Where were the children?
with her mom.
Yeah,
Opening presents that morning.
now if I may state that the original charge was assault with intent to do great bodily harm less than murder. If the prosecution was certain of those charges and that they could make out a factual basis, I don't suspect that he would have been offered reduced charge of aggravated domestic violence.
That wasn't reduced charge, counsel. That was count 2. He pled to count 2. They dismissed count 1 at the exam.
Well, David Kevin, I'm sorry, Your Honor, still.
And counsel, what does that have? What relevance is that as to what this court is stating as to the allegations?
At this point, Your Honor, it's not relevant.
Okay. Of the 4 children, sir, are those boys or girls?
We have 2 boys and 1 girl.
Okay. And so, what if somebody assaulted your daughter like that?
I'd rather not answer.
How'd you get here to court today, sir?
Uber.
How do you get back and forth to work?
I have my friend, one of my coworkers, pick me up, drop me off.
And what do you do with this program that you're involved in, sir?
Which program? The Boys to Men program is a nonprofit from my church where we take 100 to 50 to 100 young men, and we basically just give them life skills, chivalry. We show them how to change a tire. We build a wall. We show them how to tie ties. And me being a member of the church since 2010, I'm like a big brother to a lot of these younger men.
Okay, you said chivalry.
Yes, ma'am.
Okay, but what does that mean to you, sir?
Chivalry isn't dead. It's not present.
What's that?
Says chivalry isn't dead. It's just not present.
Okay, so what does chivalry mean to you, sir?
It means a lot. Manners, how to treat a young lady, opening doors, pulling out chairs.
Right, not knocking them off of chairs, right?
Yes, ma'am.
Right. So how are you helping young men learn how to do that when you are here on your aggravated domestic violence charge conviction?
I know the skills. You know,
You just have difficulty implementing those skills for yourself?
that sometimes, yes.
All right, the court's going to note that after hearing from counsel, hearing from Mr. Bailey, reviewing the report, the recommendation, reviewing the police report, the court does find there's reasonable grounds to depart from MCL 769.5. The court also finds the following sentence to be in the best interest of justice, to be reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. Bailey and the legislative guidelines. Sir, if you're in a test right now, what's in your system?
Nothing at all.
The court's going to order 24 months probation. You're not eligible for early discharge. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of this court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You are to notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed and be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. You are going to have to enroll and participate in outpatient substance use counseling. The rehabilitative goal for that condition, sir, is so you can have assistance in providing coping mechanisms so you can maintain sobriety and prevent relapse, hopefully preventing this matter from happening again. You are not to have any contact with Ms. Henderson. That's phone contact, text message, email, social media, third party, anything of the like. You are not to return to their home on Ray Street. Obviously, the rehabilitative condition for those conditions is so there can be safety for the victim and the minor children. You're not to possess or have access to any firearms or weapons. Do you have any of those, sir?
No.
You are to participate in a 26-week domestic violence counseling program.
So the court's final decision combines punishment and rehabilitation. 24 months of probation, mandatory counseling, no contact with the victim, and a short jail sentence. The goal here isn't just punishment. It's preventing something like this from ever happening again.
The rehabilitative goal for that condition is so you can further increase your understanding for responsibility of your own actions to educate you about how to change or modify your behavior when you're in a situation that upsets you, sir. There's been $0 requested for restitution. You're not to drive without a valid license. The court's going to order mandatory jail for any violation. The court's going to also order 45 days jail. I will suspend 40 of those days. You're going to serve 5. Any questions regarding those conditions that this court's put forth?
Your Honor, did you just state that defendant is to serve 5 days in jail?
Yes. I will give him a report date. He doesn't have to go right now.
And also, I did not compute credit for time, if any, that he served thus far.
Well, I'm not sure. Let's see, he posted his bond. I show a bond of on January 14th. I don't know when that bond, I don't know if that bond was nope, I'm showing January 8th. It was posted.
The bond was raised to, I believe, 20,000, 10% at some point.
Well, it was, so your client at the arraignment, the out county magistrate at the 36th district court found it appropriate for a $5,000 personal bond on December 27th. Then this court amended bond on its own motion on January 8th, which your client posted on January 8th. And so your client would have credit for, it looks like, 3 days jail, 25th, 26th, and 27th of December. I would give your client credit for 3 days.
Thank you.
I'll have your report Friday, March 13th, sir. Any questions?
Yes, can I have some type of paperwork to give to my job as far as this weekend?
Yes, you can get that from probation.
Your Honor, may the television move at the, well, now or at the report time?
The court will indicate the tether can be removed at the date that your client reports to jail.
Thank you.
Sir, just so that you're very clear, you are facing up to 1 year in jail. If there's a violation of probation, sir, or if this court revokes probation because you cannot follow the terms and conditions of probation, you're looking at up to 1 year incarceration. I certainly hope, sir, you're able to get it together so that you are not behaving in this manner again. This is the mother of your children, 3 of your children, and this is how you treated her. Reprehensible behavior. The court's going to order as far as the fines and costs go. The court's going to order a $500 fine, $100 screening assessment fee, $1,200 supervision oversight fee, that's $50 a month at 24 months, $300 for cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50. That's a total of $2,225. You did post your bond, so that can be applied, sir. There was a 10% retention per statute, which would leave a balance of $1,800. That can be applied, which leaves you a balance of $425. So you can coordinate any payment plan with probation. All right.
Yeah, right.
Any other questions, sir?
Nothing, thank you.
All right. Thank you. Have a good day. And counsel, you can stop at the window as well and pay your sanction. Let's go off the record for a moment.